Can your wages be garnished if you're self-employed? Hi, I'm Darrell Castle. I'm an attorney licensed to practice law in the state of Tennessee, and the answer to that question is obviously no. If you don't have wages, you can't be garnished. You can't have your wages garnished if there are no wages. Wage garnishment in the traditional sense is for employed people, for people who have wages that can be taken by their employer by the order of a court. But if you're self-employed, you're not exempt. You are still in danger because there's such a thing as a non-personal earnings attachment. In other words, let's say you're a contractor and you install gutters for a living, and you install some gutters on a person's house, and by contract that person owes you $2,000, let's say. Well, the person that you owe money to, the judgment creditor, he's gone to court, he's gotten the judgment, just like in a traditional wage garnishment. He can attach that money that you are owed by contract if he wants to, if he knows about it, if he learns about it. He can attach it by court order, and here's where it gets good, folks. In a traditional wage garnishment, you are limited to 25%. In my jurisdiction of Tennessee, a judgment creditor can only take 25% of your pay, but in a non-earnings attachment, he can take it all. He's not subject to the same exemption. So that is a danger, and it's something for you to think about. There's one other possibility that you could lose money if you're not employed traditionally through attachment, and that is through your bank account. Everybody who's in business, who has a business, has to have a bank account. You can't operate a business without a bank. So your money that goes into that bank can be attached. And you might say, well, I'll just switch banks. Well, that won't work either, because they'd simply send a notice to every bank in your local area, which can easily be done. They have it all by list. So those are some things to think about, even if you're not employed in the traditional sense. By the way, folks, one more thing. If you get a judgment against you, if you have a judgment creditor out there looking for you, in other words, the person's gone to court, the judge has signed off on that debt, you're going to have to deal with that debt. You might as well face it and deal with it, because sooner or later it is going to catch you and it's going to cause you a lot of trouble. You can deal with it by filing for bankruptcy. Chapter 7 or Chapter 13 will deal with it. Or you can pay it. That's just about it. You can make a deal with the creditor, you can pay the debt off, you can file for bankruptcy, folks. That's something to think about.